streams whenever kind of refers to it as a guardianship, but there's actually two parcels to the guardianship. The first one is going to be the guardian of the person. And so that's the person who's going to be able to make medical decisions, determine if somebody's going to get employment, where are they going to live? Are they going to continue to go through school? Those types of things. The conservatorship side then is the conservatorship of the estate. And yes, an incapacitated person has an estate. I will tell you, whenever I deal more with my elderly patients or elderly clients, the focus is a lot more on the money. Everybody wants control over the money. Nobody really cares about that guardianship side, unfortunately. The good news is that whenever I deal more with my, disability realm, what I deal with a lot more is there isn't a whole lot of money there. And instead the focus really becomes on the individual. So I get to sit in like a middle portion of where I run the gamut on both sides of these things. So just knowing that there's a difference. Now, normally I try to get both at the same time. And the reason why is if I only get one, and then I later need to go in and get the second one, because we say, oh, well, this individual didn't have, let's say that they had only SSI or Medicaid or something like that. So that's managed through what's called the representative payee process through Social Security. If that happens, they say, okay, well, I'm managing that. I don't need it right now. But let's say that individual is in a car accident and now they're receiving some sort of money as a result of that. Well, that money is going to disrupt benefits. And so now I got to try and rush to the court to now put the guardianship on, which becomes a little bit problematic, especially if we're looking at any of the waivers. So if there's an underlying intellectual disability or developmental disability, there's certain waivers that are super important to providing, care, especially inside like group home settings, independent living situations. And so, we don't want to disrupt those because it could be a 20-year waiting list to get them back. And so I'm very, very cautious about what benefits might be further on down the line and what do we need to protect against. I think I'm getting ready to file guardianship tomorrow. That it's the first time I think I've filed just a guardianship in years. And it's the commissioners hate that I do this because they don't get paid as much and it's a lot of work for them for $25 when they normally are getting hundreds. But it's really so my clients don't have to pay me thousands of dollars to get back into court again. So that's kind of how I approach these things. What does the process look like? Because I do get that a lot. So our code is very, very clear on what needs to be contained inside of the petition. And depending on what jurisdiction you're in, some of them read the petition, some of them don't. I will tell you that if you are filing in Virginia Beach, their law clerks, before they will even accept a filing, will review to make sure that every single element of that petition is contained therein. They will also review the final order and try to tell me what does and does not belong in there, and I tell them that I will take it up with the judge. So I deal with it on a regular basis. And guess what? I've never had a judge tell me no on these things, so that's great. I say that in my next one, he'll tell me no. So I have to complete the petition. It's very, very like gotta dot I's, cross T's, very factually based. And at the time I file that, I have to request the appointment of a guardian ad litem. This is not the same as what happens, like if you've ever gone through a divorce situation and the kids have a guardian ad litem. We have to have special certification. So in Virginia, you have a guardian of a minor, or a guardian ad litem of a minor, and a guardian ad litem of incapacitated adult. And there are two different courses, two different certifications, and we have to take different CLEs to maintain those certifications. Now, whenever I speak on these subjects, I'm talking about Virginia specific law because there are different laws in every state. Some do not require a guardian ad litem at all. But, it is what it is. Some have guardian ad litems that are non-attorneys. In Virginia, every single guardian ad litem will be an attorney. It's one of the requirements. And so the guardian ad litem, their job is to really protect the individual's best interest and investigate the matter. Is this an appropriate petition? Is this really an incapacitated person? And are the people requesting to be appointed the appropriate people? Especially in Virginia, there is an attorney that's a pretty bad rap, and he's one of my, I've known him for years, and I understand the background, like the back end of the cases and what people don't like. So every once in a while, for instance, for my elderly clients, somebody goes in the hospital, and let's say that they're on a ventilator. There's very few facilities around here. If anybody's a doctor, Getting a discharge from a hospital on a vent, there's only a few locations they can get discharged to. And so a lot of people, especially in this area, they want to go to Lake Taylor, because that's the only facility locally that can take their loved one. The problem is that Lake Taylor either refuses, can't accommodate, the family's been a pain in the neck, so they don't want them back, whatever the case may be, and you can't force Lake Taylor to take them back. So what happens? The hospital says, well, I found a placement 6 hours away out in the far western corner of the state. The family's not happy about it. However, they have now refused a discharge, and it's safe discharge, one that accommodates the family. What's gonna happen is the hospital will actually file a guardianship to supersede the family, because they say the family's not making a good decision, they need to accept placement. Usually if they get to me, I say, congratulations, you can't refuse that discharge, this is what landed you in hot water. Let's just agree to the discharge and this will all go away. You get to continue to make decisions for your loved one. But this is where a lot of the bad stuff, I would say, in Virginia, whenever I really hear, like for my elderly clients in particular, that's what is making the news. And so when you understand the facts and the rights, it's like, oh, well, this makes a little bit more sense. People don't like the attorney that now has gotten involved and is shipping their loved one off 6 hours away, right? Okay. So guardian ad litem is going to meet with the family, investigate. They're going to file an answer, and that's on behalf of the individual, but it represents their best interest. So it's important to understand that while the guardian ad litem is an attorney, it is not the respondent, the person we're getting a guardianship's attorney. Their job is to represent their best interest. Under the statute, if they believe that there is something afoul, then they will request the appointment of an attorney to represent the individual. I have had that happen. The other thing is that the individual basically protests the guardianship and says, absolutely not, I don't agree with this. Certain courts in the area will actually require the appointment of an individual attorney, and will also require the appointment, the guardian ad litem. So they'll actually have like 2 people. I'm seeing this more out in like Isle of Wight and Suffolk. It's becoming more and more common. But whenever I get what I call the frisky ones, I sometimes, I just gotta come up with layman's terms. That's my maiden name, so that's what I do. You gotta kind of navigate that. And so what should seem like, hey, this is, in and out, every once in a while, even I get thrown off because the judge says absolutely not. I had one where I was the guardian ad litem. We're out in Isle of Wight, and the woman, she didn't want to answer the door. She kept telling me she's going to throw me out. She didn't want the guardianship. She was falling and hurting herself. So now she's a danger to herself inside the house. Clearly can't make decisions. But because she said, I don't want this, I don't want anybody in charge of me. Oh, by the way, she was failing to pay her bills. Her electricity had been shut off. We're talking the gamut, right? We had to delay the hearing for 2 months so that we could actually get an independent attorney involved. And so if I'm dealing with Isle of Wight, Smithfield, I now kind of know that that's going to be coming down the pipeline. The judges here in Hampton Roads, that trend hasn't hit, but what you will see is the trends normally go from up north, and then we are the last to kind of get it. So some of the stuff that like Fairfax County, Arlington, that they've been dealing with, and my friends that practice up there are dealing with, it takes a while for it to kind of matriculate down here, but eventually it does. So I get like a little bit of a heads up from my friends up north, so that's always really nice. Contested guardianships have been on the rise too, so that's just important to know, which increases the cost. Essentially the person, assuming that they have money, the individual that we're seeking the guardianship for, they will be responsible for the payment as long as it was brought in their best interest, and the court has to make that finding. It is very, very hard to find that a petition was brought in bad faith. I've had it happen one time, and it was more on the appeal side, not on the front end side. So, just kind of understand, like, these are not cheap processes. We are seeing more and more contests that are coming involved. And as you guys know, when you've got mental health involved as well, sometimes they can be very vocal about not wanting to have a guardianship. So we'll see what leads us that way. So once the guardian ad litem meets with everybody, files their report, what's going to happen is we're going to go to court. And most of the court, the judges are good. They have looked at something ahead of time. Very few judges require me to actually put any of my clients on the stand. There was one in Portsmouth that I used to have to do it all the time. It didn't matter. Look, he brought me in on Christmas Eve one time and was still giving me the runaround. He had nothing better to do than drill me for an hour on a very, very basic show cause, whatever. But so there are times I always tell my clients, I don't know what this judge may do. We've just got a whole bunch of brand new judges in Virginia Beach, and they are still trying to even learn the process. I had one judge recently, I was talking about special needs trust. Why did we need it? We needed to protect Medicaid, SSI, these types of things. And I built that into my guardianship on the front end. And literally the response was, oh, I didn't know that estate planning had anything to do with taxes. Well, I wasn't talking about taxes. So that's kind of what I'm dealing with. So just so you guys know, it takes the bar to also train, because a lot of, unlike other states, these judges, they could have been city attorneys. They could have been divorce attorneys. You don't know what their background is. And so, sometimes there are these little complications that do come up as we're getting new judges. They also get new law clerks every year. And so sometimes that creates a little bit of hiccup for us too. But for the most part, once you know the judges, you're going to know like, hey, this might be a problem. We're going to address it, or I might have to put you on the stand, whatever the case may be. So I try to warn where I can, but for the most part, the judges have read it. Do you got any other things to proffer, whatever, and they just kind of sign the order at that point in time. Certain courts, they've seen the order form and gotten in there. When they endorse the order, that's not the end of your day. What happens once the order has been entered, depending on whatever those terms are, is you have to actually then go to the probate court. So nothing's official until you go into the probate court. At that point in time, you're going to take an oath that says you're going to abide by your duties as guardian conservator, and post whatever bonds that the court is going to require. So if you have an attorney that has done as many of these things as what I have and deals with the special needs arena as much as what I have, I'm going to try and carve out as much as what I can. So fundamentally, if I'm doing a conservatorship, most conservatorships, the law says that they shall require a surety bond, which means that there's going to be an insurance policy put on this that says, if you guys mismanage the finances, they're going to put the money back into the estate, and the insurance company is going to come after you then to, make it whole. However, if I am dealing with somebody who has less than $15,000, I can actually carve out in that order that says, this person's indigent, the estate is less than 15,000, and so it's an unsecured bond. And so that makes life easier. Then it brings down the cost where, there can sometimes be cost. I have never seen a guardianship require a surety bond. I'm not going to say that there's not going to exist, but in my cases, I've just never seen it. So that was kind of the easy thing to get through. Now, prior to July of last year, we just had a major overhaul of our guardianship section, and our state legislature has basically put guardianships on the attack. And it comes from two bad cases, one of which is out of Fairfax. I know both the attorneys involved, but bad facts also make for really bad law sometimes. So now what we have happening is we now have to do an annual periodic review. There is a mandatory that they have to be heard at least for the first year, within the first year, and then I think with a minimum of 3 years or something. The judges have been very reluctant to impose those. So that's really good for my clients because, especially you're the parents, there's nobody else involved. Why do we need to go to court every year? And especially if it's somebody who's now just transitioned to 18 or 19, I'm the parent. Like, this is what I've been doing for forever. I'd love for the judge to see, like, they'd be the one chasing them down the road to try and get treatment or, whatever the case may be, right? They have to make findings that basically, the periodic reviews are not necessary. And in Virginia Beach, they're going to require very specific language and findings in terms of not getting those periodic reviews. Since July, I have only had 2 that have actually required the periodic reviews. So, it's not something we're seeing very often. I know why they were put in from the General Assembly side, but just to be on, if you're not used to that process, any of the new guardianship conservatorships, this is a potential that we're going to have to deal with. And really it's the people that are fighting, right, over mom and dad. That's where we're normally getting it. Divorce cases, those types of things. And trust me, my least favorite one is whenever we're doing a guardianship in a divorce case, just because they're fighting over the kid. I really hate those. If you ever want bad stories, trust me, I got them all lined up.
That's awesome.
And well, the good news is too, is like, because I can see both sides, whenever families get really frustrated about why is it like this? Why do I have to jump through this? It's my kid. I've always done this. Why do I got to do all this work? And I said, because there are bad actors out there, right? There are people who exploit other individuals. And so that's what it is. So we go to probate, you guys get certificates after you've posted your bonds, you do whatever. Now your job still's not over at that point in time, right? You're now responsible for all the decisions. Now, one of the questions I always get is, so if they do something bad, does that make me responsible? You're only responsible to like you would a kid, right? So to the extent like you could have otherwise stopped it, you should have known, you know, whatever. You could be liable for something like that, but if it's, they went out in the middle of the night, they were over at their group home or whatever, the thing is, they run out and they go kill somebody, like, you're not gonna be responsible for that, they're not gonna come after you. You tried to put the protective measures in that you possibly could have, but you know, they're still individuals. You will be responsible if you mismanage money. Now, that said, you are not responsible for their debts. All right, that's another thing that I get. So I'm taking this on. We know that there's debts out there. There's very little assets. Am I gonna be responsible for the $26,000 medical bill? Or am I gonna be responsible for their credit cards or, you know, whatever the case may be? Good news is that doesn't make you financially responsible for their debts, right? And I'm sorry, I have allergies from October until March. We can't get them under control, so I'm not sick, but I have this cough all the time. All right, so you're responsible for making their decisions, where they, you know, what's their course of medical action, all this other stuff. There are two things that I always want people to be aware of. You are supposed to take what their preferences are into consideration. And so to the extent that they can express what their desires are, you are supposed to honor those. Secondarily, restriction to visitation is a very hot topic. That's why that's one of the reasons why our laws got changed, is because there is a case out of Fairfax that involved the restriction of visitation. So the proposed law that I got struck down about 2 years ago was that the guardian was going to be prohibited from restricting visitation. They had to go to court in order to do it, so it's putting the burden on the guardian, right? But the problem is that you probably all are aware that there are going to be cases where you need to act immediately because that individual going in there, and I like to use, you know, my drug addict cases, my sister, for instance, you know, we don't want her dealer going in there, but we didn't know that they would find her, you know, she would call them or whatever the case may be, right? The problem is that under the proposed law, we were not gonna be able to stop them. I'd have to get into court and magically we we're gonna be able to get in within 10 days, which if you've ever had to go through a guardianship, just does not happen. And it was just a bad law altogether. So what the law eventually became as of July of this past year is that the guardian can terminate. There are notices that have to go out. In my closed file letter, whenever I do these things, I actually have the language in the letter that says, if you need to restrict visitation, this is what you need to do. There is now a form petition, you can find it online, where anybody can file at any point in time to have the judge review something. And so at least we can now restrict visitation when we need to, but a pain in the neck can still file something pretty easily with the court to say, hey, Your Honor, I've been restricted, and plead their cause. So just, you know, that's a kind of major law change for those of you who have had them in place, and these are all new things. All right. So I've kind of gotten through the process. What are going to be your duties on the back end of this? Annually, you do have to file a form with Department of Social Services. And I always tell people, you don't need my help to fill those out. You know why? I don't live, eat, and breathe that individual, right? So I'm not going to know what their medications are taking, where they're currently living, you know, what's the best placement decision for them at that point in time. That's really going to be the guardian. And so those forms, I've never had a client need me to complete. They get a little bit stressed out. Can you review this? Sure, I'll review it, but I can't tell you if it's accurate or not. Anything dealing with money, there are formal accounting processes. And so very similar to when somebody dies here in Virginia, you actually have to file an inventory based on the value of the assets at the time in which you qualified. Sometimes those are zero for my clients, which is perfectly fine. And then you have to account for basically every penny you spend. And it's important to note that absent language in the order to the contrary, every single penny needs to be spent for that individual. So even if I have a married couple, I need very specific language inside the order that allows me to use one spouse's money for another spouse. And so these are not kind of form things that you should, like, any attorney who says, hey, I can just print out an order and there it is, run as far as what you can, because you really need to be thinking through these issues. I think through them a lot more because, you know, for my elderly clients, a lot of time I have to look at like Medicaid planning, moving assets from one spouse to another in order to protect them so that we're not impoverishing a spouse. But that's always important. So really, whenever I'm dealing with families that have a loved one with a disability, whether or not it's mental health, whether or not it's, you know, a developmental disability, I want to make sure that there's as much flexibility in there as what I possibly can. Now, under the public benefits rules, I'm not gonna necessarily be able to move assets back and forth. But I do want to think about the ability to set up a special needs trust if and when necessary, right? Some courts are gonna make me file it ahead of time and they want to approve the language. They've gotten a little bit more lenient on that because of the way I now word my order, where it's like, these are what the terms of the trust have to look like. And so it's not that, for instance, the conservator could just benefit themselves to the detriment of whoever would have otherwise inherited. Some of my families don't like that because they may say, well, dad's not involved. I'm the one running around chasing our son, and why should he get anything at the end of the day? But the default law is dad's entitled 50%, mom's entitled 50%, and the courts are not necessarily going to waiver that. I've had the courts only do it a handful of times, and it's like there was reports of abuse, like all kinds of stuff. One time dad was in jail and was serving a life sentence, so it didn't make sense to leave him anything under those conditions because he wasn't going to contribute anything. Like I said, I've got some interesting stories. I also do this work around the country, so whenever I talk about public benefits and special needs trusts, that stuff, I actually work around the country on that stuff, so that's where I get even bigger perspective. All right, so you're gonna file an inventory, you're gonna file an accounting. If person is individual or indigent, they're on Medicaid, the cost to file those are only gonna be $25. And so I always tell people that $25 a year, every month, even on SSI, you get to keep $40 out in the worst case scenario. That month, we're gonna make sure that we can pay for the commissioner's fees. It's a heck of a lot better than having to pay me exactly what you paid me the first time to do it again. And with the cost of everything, it goes up every year too. So, that's why I tried to do the guardianship conservatorship. There are plenty of practitioners out there who do not do that. And then somebody will come into my office and I say, congratulations, we get to do it all over again. People are not normally happy whenever I have to say that. So, all right, so we just got through the guardianship piece, kind of from nuts and bolts, start to finish. Anybody have any questions about the guardianship itself?
Well, is conservatorship and guardianship two different things?
It's the same process, it's just about the power that you have. So the guardian has the powers over the person, right? Medical decisions, what course of action you're gonna take. And then, the conservator is strictly financial.
Okay.
And sometimes they're not the same person, and that gets really interesting whenever you're trying to make placement decisions, because guardian may say, I want to place here, conservator says, I don't want to pay for that. Right, and so that's always a load of fun. I did want to point out, especially for this group, that somebody who does this on a regular basis understands the mental health side of things. Yep. Oh, okay. There are some code sections in which you can build language to do a TDO inside of a guardianship. All right, and so your standard form is not gonna have this stuff. This is stuff that I have to like sit down and look at. But the court can authorize an individual to be permitted to do a TDO without, the big giant fanfare. But they can only consent to the admission on behalf of the individual for no more than 10 calendar days. And so there is an ability to build in your order to allow for you to be able to consent for that. So I always think that it's important, especially for your community, to understand that if that's not in your order, you cannot consent to the individual's admission. You're gonna have to go through the formal TDO process instead. I try to make things as easy as what I can. I always tell people, if I don't have to see you for a couple of years, it means I might have done my job right? And if I do estate planning and I don't have to see it until you die, I've probably really done a good job. So I've got enough on my plate. All right, any questions about any of that?
I had a couple. Guardianship. And I don't know what it protects and what it doesn't. Can a person that's under guardianship go out and enter into a contract?
It depends on the provisions in the order, but fundamentally the answer is going to be no.
How would somebody do?
Well, you can undo
How would
it.
a car dealership or a musical instrument store know that this person? I had a son who was just taken advantage of.
Mhm.
And I have no recourse, there's no guardianship, there's no power of attorney yet. So if they can enter into a contract, if they can sign their name, that place can ruin their life.
So if they have the capacity to enter into a power of attorney, they had the capacity to enter into a contract, because it's actually the same level of capacity.
Wow.
Okay? Do you understand the nature and effect of the document? So I get a lot of powers of attorney that were probably not valid from the onset that come into my office, okay? So fundamentally, do you have the capacity to execute a power of attorney? And that's why I said, I don't just go into court and say, hey, by the way, this person has a diagnosis, so we're gonna just do a guardianship. I wanna know, is this person gonna be able to understand the fundamentals? Somebody else is able to act on your behalf, these types of things in order to go that route. I had, or first year of my practice, I have what I call the dancing girl case. And it involved the car dealership and a dancing girl. And what happened there is that, wife would have to go to work, husband with, impairment would have a dancing girl come over to the house. Next thing you know, he was signing for a car for the dancing girl, I think a brand new Corvette. He had no clue what he was doing. So mind you, he's already signed and now we've got to clean it up. That's my specialty is cleaning stuff up, by the way. So what we did is we went and got the guardianship done, had him declared incapacitated, and because we had some doctor's evaluations, the doctor had been seeing him, it was very easy to say at the time in which this was done, he didn't have the capacity and we could undo the transaction at that point in time. If you have the guardianship in place and he runs off and goes and does something, or somebody throws a piece of paper in his face or whatever the case may be, the good news is no, he's already been declared incapacitated. The order clearly states that he can't consent to, he can't enter into contracts. Sorry about your luck. I don't know what to do now, to do for you, but my son's not responsible.
And this probably normally falls on a family or a friend. I was wondering if there's a professional designation, like a certified financial planner for a guardianship, to avoid any conflict of interest as a fiduciary to protect your son, daughter, whoever.
So no, and professionals are getting out of it. More and more, and the reason why is because the periodic review thing, right? A lot of my friends who, I will never serve as guardian, never serve as a conservator, I've got 8-year-old twins, I've got other stuff going on, I just do not have the time, to serve in that role. I do, and you get paid beans to do it. So when you talk about the payment side of it, on the conservatorship, you may be able to get 1% of the individual's assets over the course of the year. And from a guardian, they still limit the amount. And so that's where you kind of run into issues from the professional side. There are a couple organizations that will do it. So you do have a public guardianship program. They're overloaded. And if the person is indigent, they will essentially say, okay, who's going to pay us to do this? Jewish Family Service, Catholic Charities, they actually have agreements even with the city. If the city has to impose it, that the city will compensate them for serving in those roles. We do have an organization, it was started by, some of my colleagues. It's called Tidewater Elder Services. But they will still be picky about who they're going to take on for guardianship conservatorship. The issue is that when you have a mental health diagnosis, even fewer people want to take it because you can't force it. I've often said that if people want to serve as a guardian from a public realm, I don't think they should be able to pick, right? Nope, the judge says, congratulations, you're the next on the list, you get it, right? I don't think that we should be able to pick and choose. But they do, that's what they're getting around right now. And so even if you see anything in the news about, hey, this attorney is doing this because they're making so much money, let me tell you, our time is much better spent somewhere else. Every single attorney that I know that actually does it, they have to limit the amount that they do because there's now visitation requirements. You've got to physically visit twice. You can delegate the visits 2 times out of the year. So 4 visits per year, and you've got to report that now. And sometimes they're driving across the state. They're not doing it for the money. I don't know if you saw the movie I Care a Lot. I laughed because I watched it for a few minutes. I was like, can you please tell me where to find those people? Because that's not what I'm dealing with. But so it's important to understand that when you read the stuff in the news, there's another background picture of it, and attorneys are not like rolling in the dough serving in these roles. So unfortunately, we do have limitations on who's going to step up and handle it. And if there's a sex offense, by the way, it's even more impossible. Because I do get that too.
Who would most benefit from a guardianship?
So fundamentally, and I just had this discussion earlier, are they incapacitated? And so if there's no power of attorney, no advance directive, and they're incapacitated, that's really who needs the guardianship. Because if somebody does not have capacity, they can't sign a power of attorney. They can't sign an advance directive. And so it's going to be anybody who needs some sort of assistance and they're incapacitated. I always try to get documents put in place, whenever I can, especially I have them for myself. Whenever somebody turns 18, everybody needs them, because the second that you turn 18, they don't care that you're mom and dad, your decision-making authority now has gone out the window. And even for my children with developmental disabilities, their pediatrician may understand what's going on, but sometimes even the health insurance company doesn't cooperate with the parents because, nope, they're 18, they got to speak for themselves now, absent a court order. And so that's really, it's gonna be anybody who is technically incapacitated, can't make their own decisions.
So what are the first steps if you have especially a indigent family with an adult who's incapacitated, adult child who's incapacitated? What are the first steps for that family to try to get the guardianship?
Guardianship. So the city, unless there's a routine kind of thing, the city will not normally step in because they don't want to have to bear the cost associated with it. There is a free service or like a nominal service out of Williamsburg that will do them. The problem is you are going to get a very bare guardianship. And I always tell people, doesn't matter what you do in life, right? If you go get the shoes that are gonna last you for 20 years, they're probably gonna be a little more expensive than the ones you went down the street and got from Walmart, right? Same thing with legal services. The people who do this on a regular basis, who are really gonna build out the powers like the special needs trust, the TDO powers and everything else, you know, they're going to charge more. It's the law school though, William and Mary has a law school program for indigent families, indigent only. And they're not gonna build out any of the special stuff. So it's all law students that are doing it under supervision of one of their law professors.
Even if they asked for it, knew, like even if.
I
she
don't
was
even know
able
if they
to
know the
advise,
language.
But
Well,
if
let's
she's
say
in
there
a
is somebody
position to advise.
advising who can say, you know, ask about this, ask about that, those kinds of things. But they are available for indigent families who are.
Well, they're gonna say if you're indigent, you don't need a special needs trust. Right.
Right, but I mean, most of the time, they're looking for simple guardianship so
Mhm.
they can communicate with the doctors and the therapists.
And a bare order will get you just that.
Right.
Okay, and so that's whenever I say like, you're gonna get a bare order, that's fundamentally just what a basic guardianship is. It's gonna be all that additional stuff that I talked about, like I wanna build a conservatorship in, so that way if there is a windfall for something or whatever, protected, yeah. So it's a little bit different there, but that's because what you're dealing with law students who, I tell you this, I went to law school, I thought I knew a heck of a lot, graduating law school, I passed the bar, I was like, yes, I know so much, and then I spent my first day and I'm like, oh crud, we don't know anything. So any attorney who fresh out of law school thinks that they know something, and even after a year thinks that they know something, run from them too, because they don't know anything, and they're not willing to recognize they don't know anything yet.
But they could practice down here, they could set it up for.
Yeah, and they've been doing them remotely, so I was actually in Chesapeake one day, and they were doing them remotely. Now, not all courts are going to allow you to do anything remotely. So that may cause like some hindrances, like Virginia Beach is very much, they want you there in person. Chesapeake is a little more flexible. Norfolk has been pretty flexible. I don't know about Portsmouth, because they've got pretty advanced systems now because of the new courthouse, but they let all their criminal defendants come in now virtual, because, you know, it's the same day as like the sentencing hearings and stuff. So as a non-criminal attorney, those are like my fun days, because I get to, you know, watch all the stuff that I don't do. But so it's just gonna vary upon court on what the law students and the attorneys are gonna have to do over there, but there is like a course over there for it. Yes.
So I'm a home-based medical social worker, for a hospital. So I get this question a lot. I actually have a family that I'm trying to meet with, and I know that that's their question, is about guardianship and things like that. Like how can I guide them kind of through this process? Like, what can I tell them? Because we get this question a lot, like, you know, mom needs to be a guardian, and so, you know, I get that kind of.
You're gonna find a law attorney. I mean, to try and go through it, I don't, like I said, Virginia Beach, you can't, I know attorneys that have tried to do a guardianship and they get them kicked back. I mean, there's some that have filed 3 or 4 times before the court finally accepts their petition. And so that's just causing more delay and everything else. And if it's gonna be contested, it's gonna be even worse. But really, this is one thing that I will say in everything that I do. I always say, if you wanna do your estate planning, go right on ahead, because I get paid a heck of a lot more if you did it wrong on the back end anyways. I'm very honest and transparent, just so you guys know. When I have to joke about stuff, I deal with death and disability all day, every day, and that's all I deal with. But no, the guardianship process, I think, is probably the one where it's so statutory, it's so, I mean, you're stripping an individual of their rights, which means I don't take these things lightly. And so really having that consultation, truly working with a practitioner that understands what they're doing. And then, like, if they're an elderly person, there are things that I need in that order just so that I can protect assets, or, you know, if it's a married couple, whatever, to try and navigate that on your own. What I'm gonna tell you is then when they're like, okay, well, I did the guardianship, can you help with Medicaid planning? I gotta go back and do it all over anyways. So, and now we've just caused an even bigger delay for services. So that's probably the one where I would just say, look, you really should go talk to an elder law attorney about it. We good? Okay, so let's talk about benefits. You ready? Drink from fire hose yet? I feel really bad for my families who come in and like, they don't even know that, hey, there's benefits out there, there's waivers or whatever, and I'm like, oh, no, you guys gotta focus on this stuff too. All right, so when we look at benefits, there's two different main categories that I look at, okay? There's needs-based benefits, and then there are non-needs-based benefits, all right? So think fundamental social security, right? You worked, when you hit retirement, it's yours, and they don't care what you have. Social security disability, same thing. You've gotten hurt, you were employed, you had enough credits. As a result, you now get to latch into the SSDI realm. There is an income limitation because fundamentally, the way Social Security defines disability is, are you unable to maintain substantial gainful employment? And so if you're able to work, you are not disabled. So really the big things in Virginia that we look at are going to be your Medicaid system, all right? And then your SSI whenever it comes to what are the means tested benefits? What do I need to protect whenever I'm looking at something? There are waiver benefits out there that will help with like housing and making sure that attendants can come in and help take care of people. The problem with that is that if the only diagnosis is a mental health diagnosis, there's no help. So the waiver programs specifically say that it has to be a developmental disability, exclusive of mental illness diagnosis. And so that's, I just met with the family the other day, they're like, we need help. It's actually an elderly woman who had a really delayed onset of some anxiety disorders. She had hit her in her 50s. So I was like, wow, that stuff normally happens at a much younger age. So kind of, shocked me. And I like had to say, I'm sorry, but like, there's not anything that's gonna help babysit your wife. The other waivers, if it's not a developmental disability waiver, it's going to be, what's called the CBC in-home care waiver. And it's not called in-home care waiver, but that's essentially what it is. It's gonna pay for in-home services. In order to get on that waiver, you have to be what's called skilled nursing level of care. And so we have to look at, are they unable to meet without assistance, 3 out of 6 of their ADLs. And so what's an activity of daily living? Physically feeding, bathing, dressing, going to the bathroom, walking and transferring. If they're walking with a walker, they need assistance walking. And usually if they're walking with a walker, they should not be bathing independently, right? Because that's probably their biggest danger spot. And usually there might be some needing assistance, like getting in and out of chairs or going out the toilet and all that kind of stuff. So what you hear me saying is in Virginia, our waivers are going to be then limited to, you actually need physical care. So once again, we've kind of got a gap in being able to get any benefits just because we have a mental health diagnosis and we just need some supervision. Your SSI, what they're going to be looking at is, are you unable to maintain substantial gainful activity? And they put a dollar amount on it. It's about 1,300. I haven't looked at the 2024 numbers or memorized them, I should say. I've looked at them because I pull them all the time, but I just haven't memorized them. They change every year. And so if you're able to, if they say you're able to make this amount of money, they're going to say you're not disabled. And so that's why I say there's a technical definition of even disability whenever I start talking about disability. I do a lot with the Autism Society. And there's a spectrum there. And so when I start talking about the autism, with people, individuals with autism, they come in, they want benefits. And I'm like, but they're going through college, right? Like they're matriculating, they graduated with honors. The Social Security Administration is not essentially say they're not disabled. They're not going to look, they're not going to necessarily see like, hey, by the way, from a social perspective, we've got some issues here. Every once in a while we can get them and you've really got to prove it, or they've had to try and work and they're not able to maintain the work. It's like kind of like in and out. So just kind of, to understand what we're talking about in the disability realm, that's really what we're talking about. When you have an individual with a disability, and probably one of the biggest failures of my clients when they have a loved one with a disability is not getting that disability determination while they're still young. And the reason why is that if you have an individual who is your dependent, so like you're a dependent child that was disabled prior to the age of 22, then what will happen is they will latch into your work record. So if you have a kid that is not going to necessarily work and whatever, fighting for that SSI determination is super important, because now when you retire or if you become disabled yourself, they get to collect 50% of your benefit, which is usually a heck of a lot more than $914 a month. Then when you die, they get to collect 75% of your earnings. So that's a good way to be able to provide, you know, later on if there's a disability. So it's really, really hard to get that retroactive. In particular, like my sister's diagnosis came a lot later in life. Their indicator probably when she was about 16, and my mom, who was a nurse, refused to accept any of them and fired the psych at that point in time. So that was a fun point in life. But you know, to try and pinpoint and go back that far for Social Security Administration, they don't want to hear it because then they're going to have to like back pay and all this other kind of stuff. I always tell people when you're dealing with public benefits, they are not your friends. I get clients all the time like, well, I called the eligibility worker and they didn't tell me I could do this. Their job is not to get you established for benefits. Their job is to review what you have submitted, right? And say yes or no, you're eligible. And so it's a very big difference between what I do and kind of what the eligibility workers do. For both SSI and for Medicaid, and we're gonna talk, there's now 3 systems of Medicaid, which confuses. I get brought into the back end of personal injury cases because they call me like, hey, they're on Medicaid, what do I need to do? And I'm like, well, fundamentally, let's find out what type of Medicaid they're on first because the rules are different. So if they're on CHIPS Medicaid because they're children, that's an income-based program. Congratulations, they got $1 million, they continue to collect. We now have expanded Medicaid coverage, which covers the gap from age 18 to 65. And that's for low income as well, which means once again, you can have assets and beyond expanded coverage, unless you're falling under the long-term care side of that. Where we get into the asset test is if it's that automatic latch in from the SSI system, because now it's under what's called age blind disabled. So if I refer to ABD, that's what I'm talking about. Age means if you're over the age 65, you are presumed to be disabled. Congratulations for anybody who's had their 65th birthday. You can qualify for Medicaid under the age portion. Blind, and then your disability determination. Disabled, you know, if you're latching into SSI, that's easy to establish. Otherwise, what they're going to really be looking at is from the long-term care arena. So once again, 3 out of 6 of your ADLs in order to latch in, because usually at that point in time, we're not looking at traditional healthcare Medicaid. We're actually looking more in the long-term care system. So if we're looking in that system, what we're talking about is $2,000 worth of countable resources. And if you're in in-home care, the income threshold is about $2,700 a month right now. They just upped it again. So once again, I have to memorize those numbers every year. So whenever people start getting inheritances, when we start talking about like personal injury settlements, those types of things, if you're on those benefits, there's special things that I have to do in order to protect them. If the individual's under age 65, it's pretty easy because I can look at special needs trusts. Now, sometimes people don't like special needs trusts because under federal law, one of the requirements is in the event that, or upon death of the individual that had the money, you have to repay back Medicaid for everything they've ever received during their lifetime. I tell people it's you can't have your cake and eat it too rule. The other option is you just don't get benefits. You privately pay for care, which can be really expensive. This money is designed to supplement the individual. And so people don't like that provision, but it's federal. I can't get around it. So that's the downside to a first party special needs trust. The second type of trust is what's called a third party special needs trust. And that's where you guys would leave an inheritance. You pre-plan it. If you die, don't do any planning and it vests down to them. I have to go first party because now it's theirs. They have a vested interest. If you do your planning, you build in what's called a third party special needs trust. The government says, well, you didn't have to leave your loved one anything. Congrats. Unless it's your wife, by the way, you can't disinherit a spouse. I have to tell people that all the time. No, because then you've given a gift away for Medicaid. So timing of that. So really then they say you didn't have to leave them anything. So there, as long as it says that it's designed for, you know, it's just wholly discretionary. It's not for health support or health education, maintenance and support, which are very technical terms that we use in trust. If you open up your trust, they're probably in there. That language does not work for a special needs trust because both SSI and Medicaid say, oh, no, this is available for your health education, maintenance and support. They can pay for you first and we come after. So I do a lot of what's called decanting, where I have to change the terms of the trust to make sure that it complies. I see this a lot, like grandma may be leaving an inheritance, but was left for their child, so they weren't thinking special needs. And so when it goes down to the grandkid, it may say, and if somebody was under the age of, 21, 25, whatever, it stays in trust. Well, I gotta get to that before they turn 21 or 25, do what's called a decanting, so it now goes in third party arena instead of going first party arena. Third party arena, once that beneficiary dies, they can go wherever you guys want it to, because it wasn't their money, it was yours. It never vested down to them.
Not on this topic, but on the previous topic, Tracy online says, can you just get guardianship over a person? She is a 30-year-old diagnosed with bipolar schizophrenia, and he believes he is okay. We hear that a lot. He says she's the one with the illness, can't have a normal conversation. They've tried everything to get him help, and no one in the city will help. It's Virginia Beach, tried TDO. He didn't meet criteria, even though he's assaulted his dad twice. Police just take him to jail. He received his diagnosis at 17. What would you advise?
So the issue is going to be in cases like this where it's like quite a big question mark, right? Is the individual incapacitated? One of the things I need in order to get through the court system is I'm going to need a medical evaluation. So that's the first thing I do. Like, if it retains me that day, letters go down to the physician. They don't always like me very much. I sometimes have to say, you're either gonna fill out this form, I'm gonna subpoena you, and you're gonna testify in court, and I'm gonna tell the judge you don't get paid either. All of a sudden, I get my form. I've had to learn over the years. But it's really gonna boil down to what the doctors put on that form. And once again, fundamentally, do they understand what they're doing? We are all allowed to make bad decisions. And so whenever I talk about guardianship, that's always what I have to go back to. And with mental health in particular, that's sometimes hard because on some things they might be fine. They might not be getting the treatment that you want them to get. They might not be taking their medications regularly. But here's the thing is even in the guardianship, you can't force psychotropic medications. There's some constitutional law issue associated with that. So that's why I tell people it's still not a magic wand. So you still get the revolving door process. You still can't necessarily force, you can't put the pill down their throat and make them take it, right? And so you still end up with the problem. So I would lean on the doctor, get the doctor to do an evaluation. If you get a good evaluation, then you would file. My clear ones, I just go ahead and file and I get the evaluation later. But in the case like that, I need the doctor to opine before anything.
Okay, thank you.
And I have had contested ones, in particular, high functioning autism. I had to save her from a prostitution ring in Amsterdam. So she was gonna get on a plane, some boyfriend of hers was gonna pay for her to go to school, and she just didn't realize that that was a thing, and so we had to save her from herself. But it took the doctors and everything else to get it.
Yeah.
So, but, any other questions? We only got like 5 minutes left. I told you there's a whole lot in here. I wanna go through, some of the questions, because there was like, can a Virginia Beach resident obtain guardianship over their adult son who lives in North Carolina? Yep, in North Carolina. So jurisdiction is going to be based on where the individual is, not where the guardian is going to be. And you can cross state lines, like that's okay that I have a guardian that lives in Virginia, even though the child may be in North Carolina. Some states crossing state lines is going to be very problematic. So Virginia Beach will not let me put language in unless I have a plan as to where the individual is going. All right, so if I try to put in and the guardian has the ability to change residence, they're gonna say, and where are they going, and when are they going, and who are they going to live, and everything else. So that's one of the conditions that sometimes I have to go back. So crossing state lines, families lose authority, and so the judges don't necessarily like it. In Florida, from what I've heard, it's like impossible to get them outside the state of Florida. So try and get the guardianship move them out beforehand. So sometimes strategic timing of this stuff is important. So yes, you can get it, you just gotta do it in North Carolina. North Carolina process, I'm not licensed in North Carolina, but I work with North Carolina attorneys. It's just a probate clerk, which is a little bit interesting. You don't go for a judge. The only time you have to go for a judge is if you need very specific powers, so like the ability to sell real property, you would then have to do a double level process and go to the judge. And that's about all I know about North Carolina. Is there a process for obtaining guardianship for a person who has not been diagnosed because they refuse to participate in the process of seeking help? Absolutely. This is where one of my exceptions of filing before you have the medical evidence. If the family desperately says, I gotta try, I'm at my wit's end, I've gotta do something, and I just need a diagnosis to at least get medication, whatever, I can go through, file, and then tell the judge that they're not gonna go seek the medical help or whatever, and request that the court mandate the the order to go see the doctor. And then if they don't go, and the guardian ad litem has to a lot of times help facilitate that process. Then if they don't go, they're in contempt and they're in trouble, and we've got to figure that out on the back end. But that's one back end way for us to try and get determine a diagnosis if we need to. There's one question where it says, what about if a teen's bored and just doesn't want to go to college? Sorry, I can't help you there.
Oh my God.
Yeah, unfortunately, I'm a millennial, first year millennial, but guess what? Older millennials are not the same as young millennials, and then when you get even younger, it's even more rough. My girls, I'm teaching them responsibility. They got brand new dogs and they're responsible for those dogs every day that they're there. Yes.
So what does, our parent need? With the disability to help them facilitate, like, through Virginia Beach City to help them with a case manager, because you know how they'll tell you, well, we can't speak to you. So in that case, what is someone do?
So go back to, do they understand what they're doing, right? And I had to fight with the CSB at times. I actually had one time where the CSB was refusing to listen to mom, even though the girl like couldn't even speak. Right? They're like, but she looks so happy here and I know you want to move her, but look at her, she's smiling and nodding, she wants to stay. And I'm like, oh dear God. So, I've also had to fight the CSB where the son decided he no longer wanted to do some of the household chores that his mom had taught him to do. And so he just figured he would get his attendants to do it, and mom was not having that. And the only way to supersede the CSB was that the son was 52, he had Down syndrome. Mom was probably one of the first special needs educators in like the country. So it was really interesting. We've got that far, and just because the CSB was refusing to listen to her, like, no, he needs to do this on his own. These are skills that he learned. I had to go get a guardianship over that kid.
Oh, good.
So it was really horrible. I hated that. So in that case, if they're refusing to talk to you, okay, and you just want to be able to talk to them and he understands what he's doing, then you can get a HIPAA release, right? Because that's a release of medical information, and you don't have to do that in a doctor's office. We do them pretty much standard with our plans, unless people just want the privacy. There is often a restriction though for psych doctors, and so we do have a release of psych notes as well that we can do to make sure that you can talk to the psych doctors. So those two documents, if they understand what they're doing, will allow for the transparency. Sometimes, even better, sometimes they don't understand the difference between power of attorney and all these other documents, and they want to see a power of attorney, so sometimes you might need the power of attorney as well, even though power of attorney is just financial. But everybody wants to see the power of attorney. And then, sorry, every once in a while, like, things pop in my head. Like, I remember when I had my twins, I was on mag sulfate, and for any medical providers, that's like toxic to your system, and like, you don't know what's going on. They were asking me questions about my twins, and I was like, I don't know, my mom's a medical agent. He's the father, let them pick what's going on, right? And I said, my mom's like, just sign it, and she's a labor and delivery NICU nurse. And I remember saying, okay, but this is not legal because I have no clue what I'm signing. So I just like popped in my head. So every once in a while I get that too, where the providers, they'll still force you to sign stuff and you don't even know what you're doing.
Excuse me,
but-
with the HIPAA release, is that something that's legal to get a HIPAA release? So they have to have legal documents to get that, and so does the individual who's affected have to sign a?
Yes. You'd be surprised sometimes, like when you can get them through a period of like their medication is stable or, whatever, some crisis averted. Sometimes, when you can get those moments of clarity, that's like your jump spot. Like there's no delay. It's like, okay, like this is when we need to do it. And it's sometimes just difficult, but here's the thing is if they refuse, they are still like, they don't know what they're doing and they're not being honest with the doctors or whatever, we need to go guardianship route. So that's in the other alternative. If they don't know what they're doing, you've got to go guardianship route so that you can talk to the doctors.
Tracy, the mom who asked the question before, said, who do you go to in the court to file a petition?
The clerk of court.
Okay.
You gotta have paper, play what you're supposed to plead, and you gotta file with the clerk of court with $20.
Thank you.
You're welcome.
Tracy, thanks you.
Yes. All right, no question?
You have a HIPAA release for every healthcare professional.
No, that's the difference. So normally when you go to your healthcare providers, that's their form, right?
Right.
And I just had to fill out one today. I do one that follows you, because remember, it's federal law. And so it's you're releasing regardless of what provider it is.
If he's signed one, but he doesn't with one doctor.
Yeah, nope, it won't carry. It's their practice. Cause it will specifically, if you look at it, say, I hereby allow you to speak with, and you list the names, and it's practice specific.
Right.
Not,
They can rescind those, they can revoke that.
they can, and so that sometimes becomes a problem. So one of the other things in a guardianship is I have to argue that it's the least restrictive alternative. And so sometimes we have to try the documents, because maybe they're in a moment of clarity, you know, mental health, it's like there's good, there's bad, and the judges are, you know, some of them get it, some of them don't. And so if that happens in the revocation, then we've got ground to stand on. This is why it doesn't work. They're just revoking them every time they have these manic episodes or whatever. Yes.
What are a couple of resources, websites, books, whatever that you might recommend?
So that is super duper hard, and the reason why is it's so state specific. And so to be able to find a publication, I'm licensed in Pennsylvania too, and the process up there is just completely different than ours. And so it's really, really difficult, and the laws are different. I mean, we just completely went from the uniform statute we had in July, like now it's like this big thing that has completely changed, and practitioners don't even know there are changes. So unfortunately, there's not gonna be a whole lot out there. The Virginia Guardianship Association used to put out a really good booklet that talked about like your duties as a guardian. But the problem is that there's gray areas in this stuff, right? Like there's no black and white out there in terms of, hey, this is everything you're gonna experience. You know, so a lot of, I think any resources, it's gonna be a lot more like the support groups in terms of like, these are the experiences I've had, these are might be some things that you might wanna try, those types of things. So I don't actually know of any like professional publications that are gonna talk about like, hey, this is what everything is, and that's just gonna be because of territorial limitations. Sorry. Question?
I just have a question on the third party trust.
Mhm.
So it's already established in my will, but it hasn't been set up. So it gets set up when I die.
So your will doesn't exist until you die. It's only a document.
Okay.
So, this was the hardest concept for me in law school, was when documents come into effect, because it was called the rule against perpetuities, whatever. So a will only takes effect when you die. And so that's then when that trust will get set up and get funded.
I have a question about, so we've got guardianships in place, we're getting older, we want to move out of state. At some point, we won't be able to handle these guardianships. How do we move them to someone else?
So sometimes it depends on, so you want another individual to take over, or you want the individual to follow you?
Let's talk about both. I ask someone else to take over if they choose not to follow us.
So, you know, I talked about the transfer stuff. It's funny because there's a uniform guardianship, it's like the Uniform Jurisdictional Guardianship Protective Proceedings Act or something, like it's like 10 letters that I've got to say. That act, it was supposed to make everything much simpler, transferring from jurisdiction to jurisdiction. I think it costs double. Like, it just drives me nuts, but there's no way around it. And so what happens, I'm doing one with now, Maryland essentially said, you moved out of state, you've been there, you know, you're not coming back, so you need to reestablish a guardianship in Virginia. They are a uniform state as well, and so what I have to do is I have to get their court to say that they're going to provisionally transfer to the state of Virginia. Virginia, then I've got to file the petition and do everything here in Virginia so that I can get our courts to say, we're going to provisionally accept it. And then give that order to Maryland, and Maryland says, oh, congratulations, they're gonna take this, they're gonna enter a final order saying we're hereby release, this is all your final things you need to do for Maryland. And then from there, then we go back into court over here in Virginia, and the judge says, oh, these are all the terms that we need to put in ours. It's interesting because I recently had a judge, one of the new judges on the bench, I was doing one for Massachusetts, I've done a lot of these transfers. And he was like, well, why do we need to do it? Because the court section says that you only need to modify to the extent that the prior order isn't effective. And I was like, that's great. Try and go to a Virginia bank and get them to enforce this. I said, I'm a lawyer. I'm not looking up every single last one of these codes because I don't practice in Massachusetts. It was a one-page form with some checkboxes, right? That, if you've ever seen our guardianship orders, they're a heck of a lot longer than one-page form. And so whenever I said that, it's funny because it didn't matter anything else that I said. And all of a sudden he was like, the best argument I've heard all day. So sometimes for the judges, it's not even the true legal argument, right? It's well, that's just simplistic, that's just common sense, and this is, oh yeah, that needs to happen, and so you just, sometimes just never know what's gonna stick, you just gotta, I'm one of those, if you can't tell, I'm like, I'm one of those people that just kind of, all right, we'll figure it out and move on down, so that's the transfer. Now, the individual, you gotta find the individual.
Yeah, so let's say we don't want the transfer, we need to, you know, burden someone else with this problem and unburden ourselves. What's the,
You gotta find them.
a person to take it up to? And if you can't, if you,
You're stuck with it.
what if you, let's say,
We might
you
take it on.
abandon your duties, can the state
You won't
do
do,
something?
yeah, they can do a show cause and, haul you into court and hold you in contempt and all kinds of other stuff. I wouldn't recommend doing that.
No.
The hard,
Yeah, but who takes on like those types of roles? Like if you know.
it's nearly impossible. I mean, that is one of the big problems. Do what?
I'm just saying, anybody short of a loved one. I
Yeah.
think
Well,
is-
what would happen if the guardian passes away? What happens?
Well, then it's on the state. They've got to figure it out
Mhm.
at that point in time, right? And
Don't fake your death.
But really, I mean, it's a lot of work. You guys know that. It's a lot of work. And so the professionals don't want it, right? Because it's gonna be a lot of work for them too. Our public guardianship system, which is probably where it should go, they're overloaded and they say, no, you're gonna pay us to take this on. And like I said, it's like Catholic Charities at point blank told me they don't want any mental illness cases. And then, you know, like I said, there's other lingering things. We might have even bigger issues.
How much is it to do the time?
It's gonna range, anywhere probably between 4,500 to 7,000, depending on the firm. It's not a cheap process, but that's why I say, I want people to pay me once, I wanna get through it, I try and think through standbys, so I try to think like if mom and dad dies, who's gonna take this over? Because the less I have to go into court, I save money.
Yeah.
All right,
One last question?
You mentioned earlier, and I didn't quite catch it, something about if they get diagnosed or they get approved for SSI before they're 22, then they get benefits from the parents. Can you, is it when they apply for SSI or is it when
it's when their disability determination, so they have to be an individual that is determined to be disabled prior to age 22. All right, so that's the magic latch in.
And disabled, I know you just trying to define that term a bunch. Mental illness, schizophrenia disabled, or the developmental disability disabled, or what?
Fundamentally, are you unable to maintain substantial gainful employment? So it doesn't matter the diagnosis.
Guardian conservatorship.
Well, and in my guardianship conservatorship, it actually specifically says for purposes of public benefit, they're determined to be disabled. So I throw that in my. Help.
Okay. So
Whether or not that's.
So which thing were you saying to get before they're 22? Which was the
They
guardian
you need to
conservatorship?
apply for SSI and you have to have their disability, like they need to latch into the SSI realm before age 22.
And the SSI realm is where they get this determination. You're talking this. More than, so if you apply at 21 and it takes a year and a half, then you're out of luck.
No, because the application went in at 21, because sometimes you get, like, you have to file the application, and by the way, attorneys do not help with the application because the federal government has iced us out. You cannot charge for an application. So anybody who does social security work, they're gonna tell you to put the application in, and if it needs to go to an appeal, then there's a process in which the attorneys can help. And so just so you know, that's out there, not because we're being mean, but just because the federal government has done that. So once it's in, if it gets denied, you immediately need to get into appeal because it's still the same application and it'll go retroactive to the application.
The application date, right? Is that retroactive? Because I know like the appeal, the second appeal. Okay, thank you.
Although I really like the Social Security Administration, they know nothing about special needs trust. The one time I went, as one of my clients, she'd known me for years, and they incorrectly ruled on something for a special needs trust. And those judges are primarily familiar with like the actual disability determination side. And so I'm like, Your Honor, this has nothing to do with whether or not the individual is disabled. They've had cerebral palsy since the moment they were born, and like, you've already got a permanent disability determination. This is in-kind support and maintenance role for special needs trust. I'm like, going to stuff, she's like, I see that a big binder there, like, is what I need in there? I was like, absolutely, Your Honor, you can totally take my binder. I got ruled in my favor very quickly, but they had no clue. She's like, what is this presumed maximum value rule you talk of? So, they very much focus even on the appeal side. It's just on the disability determination is where a lot of our judges focus their time, so. Cool.
Thank you very much. Thank you. Thank you, everybody online, and maybe if there are any questions we missed, maybe if you email them to our office and maybe our speaker, we email and maybe if Emily asks. So thank you very much, and remember, our website is all up to date with information. Have a nice day.
Thank you. Goodbye.
They don't do well.
That's good. It's not good for retirement though.
How are you? Busy? Yeah.
Yeah.
And that's what I.
Oh, yes.
But that's not, so that's not on the line, that's any questions, but. I'm sorry.
Yeah, I know.
And I know, so, but I do too much, so I mean. So I'm really. I'm looking for reason. It's like, I long process, and I know, you're better only not responsible. And she got the call, I just had it commit. And she actually had, there were no it took. Wow. Take out the house. I would say like she'll go already. Will I? There are, not people, I never put down.
But,
Oh, no problem. They're eight, and I'm taking the flight out early in the morning. But, yeah, I'm talking about there.
good, it is.
Yeah.
You worked hard at it.
Yeah, you did.
Yeah, this one, yeah, we got tough these.
What is yours? You need it? No way?
What?
Yes, I did. Let me see.
Oh, my God.
Thank you for coming. I'm glad you got some good information for you want to take everything?
I'm sorry. Everything. Okay.
Again, it was good seeing you. Hopefully you'll see me soon. I think in February I'm just come on.
Next time, she's still in the hospital. I was following services, I was all over clinical services. So she texted me. Why is your number?
Yeah, Susanna, put it on that sheet right there.
Oh, no. Okay.
I was doing more customers.
And that was.
Yeah.
See change.
You did it.
When I hear something. So, yeah, definitely. I mean, I don't know if she, it's gonna help.
About to come on.
No, she's saying, she's still on the list, but she hasn't discharged that, and that means maybe she possibly